Members, please take your seat. It's the appointed time when we have a quorum. Thank you. Members, it's time and we have a quorum. Dr. Lam, if you leave, then we don't have a quorum. Miss Rebecca Chan just wants our meeting to abort. She really doesn't have anything important to attend to. Okay, so it's the appointed time and we have a quorum. I call to order the meeting. Since the last meeting, the Secretary has issued the following documents for follow-up issues arising from the meeting of the 6th of May. That's paper number CB bracket 4588/2024 bracket 01. And then B, follow-up issues arising from the meetings of the 2nd and the 6th of May. Administration's reply, that's paper number CB bracket 4588/2024 bracket 02. There's also a paper tabled. It hasn't yet a paper number. So members, you could refer to those documents. And I see the administration's response to Mr. Holden Chow's letter. That's paper number CB bracket 4583/2024 bracket 01. Can the Deputy Secretary take us through the documents and also give us a reply to follow-up issues? Thank you. There are a number of documents. The first one, our reply to Mr. Holden Chow's questions. He's not here, but this is briefly just to talk about the practice scope and continuing professional education for oral hygienists. Now, for oral hygienists and therapists, are they allowed to perform scaling for patients in the absence of a registered dentist? We've explained this point. Actually, we have consulted the dental profession and the dental council. Now, we have a risk-based consideration. So we would like to strike a balance in our proposal. And so the arrangement, the restriction is that the dentist must be present on the same premises, while in the government organizations and other NGOs and so on, with this arrangement that will help to provide the necessary manpower for these bodies, and we'll see whether we need to review it further. Mr. Holden Chow, we are now on the administration's reply to your letter. Do you have any follow-up questions? Oh, yes, Mr. Chairman, thank you. Thank you for the response. Now, the questions in my letter, and then this morning I heard your reply to questions raised by deputations. Yes, I'm fully aware of the risk-based approach. Now, in the consultation process and in my collection of views, I understand it's good for us to have such dental care professionals to help to take up certain procedures so that dentists could be freed up to take up other treatments. But then we need to consider the risk as well. I'm not saying that all oral hygienists should be allowed to do scaling independently. I'm just saying we could take a progressive approach. Maybe for the senior oral hygienists who have enough experience, then maybe they should be allowed to perform scaling independently. And here it says that the proposal is for dentists to be present on the same premises. I know you are taking a progressive approach. What is important is that we could address the risk at the same time. We should allow the more experienced dental hygienists to take up certain tasks, because that will, in the long run, relieve the manpower shortage. That's the point I'd like to make. Thank you.
Deputy Secretary. Thank you, Chairman. In the same reply, We also replied to member about the composition and the functions of the Dental Council of Hong Kong. We have provided a response. We will actively consider members' views. We will also consider increasing the number of DENCPs to enhance its functions in relation to taking a progressive approach in view of more DENCPs joining the Dental Council of Hong Kong. We can discuss how to better encourage collaboration among them all. We will list all these in the subsidiary legislation. There is further room for amendment in the future. For the other two papers, information papers and the one laid before us, do you need to follow up on these documents? Thank you, Chairman. No, actually, no. It was just an elaboration on my oral reply on the last occasion. Thank you, Chairman. Any more questions? We will now get back to clause-by-clause scrutiny. We were on page 81 of the Chinese marked-up copy. So the administration can now proceed with page 82 of the Chinese marked-up copy. Legal advisor, you can provide legal advice in the drafting of the bill. Legal advisor, please ensure the English version is free of any problem or free of any issues. Well, Ms. Chen, probably you can press the request to speak button. In clause-by-clause scrutiny, it's the first time we heard from deputations as well as individuals. Can we continue to ask the administration questions in relation to the views from deputations and individuals? Can I continue to ask questions? Well, please hear me out. Well, you haven't yet asked all questions. You can submit questions in writing to the administration. The administration needs to read the 23 written submissions. So I think the administration can summarize all views from deputations and individuals. They can also incorporate views from members. Well, I never said that we couldn't go back. You can tell the administration as well. Well, 10:45, it's a new meeting. We don't need to rush for time. We're not going to adjourn the meeting at 11 o'clock. Well, I have already decided, Ms. Chen. The public hearing we held just now has already finished. We're not going to discuss their views. I have already made the decision. Ms. Chen, I'm not allowing you to educate me on how to be a chairperson in the meeting. I have already dealt with your views. Well, Chairman, 10:45 is a new meeting. Well, if you keep disturbing the meeting, I will have to excuse you. Well, I didn't disturb members. Well, you are not allowing me to speak, and you are disturbing the conduct of the meeting. Just now, when I pressed the button to speak, it is you who allowed me to speak. You didn't set any time limit either. So you are actually allowing me to speak, but then you are now disturbing me. So, Chairman, I request that after hearing views from deputations and individuals, we can ask the administration questions. We are now in the stage of clause-by-clause scrutiny. Just now, deputations, individuals, and professionals have already express their views. We are now in the stage of clause-by-clause scrutiny. Well, Ms. Chen, you are repeating what you have just now said. Finished yet, Ms. Chen? Well, I have to exercise members' right to ask the administration questions about the part of clause-by-clause scrutiny that we have already finished. Well, you have already asked your question. Don't repeat your question. If you keep repeating your question, I'm going to switch off your mic. I'm not going to allow you to speak further, Ms. Chen. Well, I have to ask the clause-by-clause scrutiny that we have already dealt with. Ms. Chen, I'm telling you, my decision is that for the deputations, individuals, professionals' views in a public hearing, we need to wait for the administration to organize their answers. Then, likely in the next meeting, we'll discuss the administration's response. If that has anything to do with the part of this clause-by-clause scrutiny before we will go back to it, I am speaking, Ms. Chen. If you still cut in on me, I'm going to ask you to leave the conference room. We need to continue with clause-by-clause scrutiny. We won't. I won't allow you to ask questions just because we have already held a public hearing just now. You weren't with us. You went in and out, and I have no comments. If you want to ask the administration any questions, please write these questions to the administration. Well, Chairman, you are going to proceed with clause-by-clause scrutiny, is that correct? Well, we haven't yet finished the discussion of the previous clauses. Well, we can always go back. On many occasions, the administration hasn't yet answered our questions. Sometimes you are not satisfied with the administration's replies. It does not mean the administration has not answered your questions. Well, now we'll go back to page 70 of the marked-up copy for the clause-by-clause scrutiny. Mr. Chang. Section 10 on page 70 of the English marked-up copy. There are quite many amendments. It's about certificate of registration. The certificate of registration means that a person receives a certificate of registration upon registration. If the name of a person is entered in Part 1, 3, or 5 of the General Register under Section 9b, 9f, or 9l, the registrar must issue to the person a certificate of registration in the specified form. You can see there are quite many amendments or deletions in this section. Regarding brackets 3, 4, 5, we have taken on board the industry's views. Dentists are required to display the certificate of registration. The photograph has to be the same. So we'll repeal these subsections. Regarding bracket 3, that's about register address. We are going to put it in section 12G. Members will see section 12G later on. Section 12G is on page 86 of the English marked-up copy. On page 72 of the English marked-up copy, regarding person not to practice without practicing certificate, it's going to be changed to practicing certificate required for practice. In brackets 2, it's about the requirement of a practicing certificate. In brackets 2, the council may issue a practicing certificate in the specified form to a registered dentist if A. The applicant applies to the council for a practicing certificate. B. The application is made in the specified form and contains information on the applicant's employment and practice of dentistry as required by the specified form. C. The application is supported by a declaration by the applicant as to whether the applicant has been convicted in Hong Kong or elsewhere of any offense punishable with imprisonment, and if the applicant has been so convicted, giving details of the conviction, and D. The prescribed fee has been paid. In brackets 2A, if the applicant for a practicing certificate is a person with full registration, limited registration, with special registration, the council must not issue a practicing certificate to the applicant unless the council is satisfied that the applicant has complied with the requirement regarding continuing professional development determined by the council as applicable to the applicant. In brackets 2b, if the applicant for a practicing certificate holds a valid practicing certificate issued under section 15H, the council must cancel the existing certificate before issuing the new certificate. In brackets 2c, the council may specify in a practicing certificate any condition that the council considers appropriate. It's rather long. We need to continue to read on. On page 74 of the English marked copy, brackets 3, if a practicing certificate is issued on an application made during a year in respect of that year, the certificate is subject to subsections 4a and 5 to be enforced from the time of the issue to the end of that year. Brackets 4, if a practicing certificate is issued on an application made during a year in respect of the following year, the certificate is subject to subsections 4a and 5 to be enforced during the following year. In brackets 4a, a practicing certificate issued to a person with temporary registration is subject to subsection 5 to be enforced during a period not exceeding 14 days as specified in the certificate. That is about the requirement of less than 14 days in relation to temporary registration, that is for short-term exchange. In brackets 5, a practicing certificate issued under this section ceases to be enforced if during the currency of the certificate its holder ceases to be a person with full registration whose name is contained in the practicing list, b. a person with limited registration, c. temporary registration, and d. special registration. Dr. David Lam. Chairman, thank you. 2 questions. I'd like to confirm that persons with provisional registration do not require a practicing certificate. Is that correct? Yes, that is correct. In 2A, in limited registration or special registration or full registration, one needs to comply with the requirement regarding continuing professional development before one can apply for a practicing certificate. What about application for practicing certificate for the first time? One does not have any CPD at that time. Thank you, Dr. David Lam. We set down as determined by the council. That is, it is to be determined by the council. That gives the council flexibility in relation to individual situations. That is what requirements that need to be complied with by the applicant. That is to say, for the application for practicing certificate for the first time, there could be no requirement. Is that correct? Yes, that is correct. Ms. Chen Hao-Yan. Just now, the administration said that the amendments, there are quite many amendments, and you said that you did so in response to the industry's views. Can you tell us more about the industry? What is the definition of the industry? Mr. Chang. Thank you. Regarding the display of practicing certificate in 2019, the Dental Association, Hong Kong New, and different organizations also gave us this view. In April 2023, we extensively met with different sectors, including the consultation papers and the information brief. They also showed that the practicing certificate does not have to be displayed. Did you collect these views through the Dental Council of Hong Kong and the Dental Association? Did you meet with the organization in March? Yes, we did meet with them. When? Did the administration take the initiative to call this meeting? Yes, that is correct. After February 2023, we arranged for many meetings to meet with different groups. So the requirement in relation to practicing certificate was mentioned, and they also agreed. Any more questions? No, please go ahead. In relation to Section 11B, recovery of practicing fees, please refer to page 76 of the marked-up copy. We have drawn reference from Nurses Registration Amendment Bill 2023. For practicing certificate, one needed to pay. So the Nursing Council and the Dental Council of Hong Kong considered that one had already paid and then one already had the practicing certificate and then one can apply to recover the fees. But apart from the payment, one also needs to comply with the requirement in relation to continuing professional development. So this provision does not apply any longer. Please continue. Section 12, dental companies on page 77 on the marked-up copy. It will be repealed. Let me tell you a little bit more about the background. Before 2018, we didn't have the relevant provision or ordinance to regulate the relevant matters, so we needed to rely on Section 12. But in 2018, the private medical institution ordinance had already provided that the DOH will be responsible for these matters. So Section 12 will be repealed in order that the provisions do not have to be complied with. This will be repealed only when CAP 633, the Private Healthcare Facilities Ordinance, takes effect. Dr. David Lam, how do you make sure that the practicing certificate will be given to the applicant before the next year? Otherwise, the applicant may not be able to practice. We'll maintain a close dialogue with the industry. One needs to obtain a practicing certificate before one can practice, or else one will be subject to disciplinary hearings. Well, that wasn't the case. In the past, when one already paid, one will be deemed to already have obtained the practicing certificate. It doesn't matter if the practicing certificate is mailed to the applicant later than the payment. If somebody in the DOH has not yet obtained the practicing certificate, what about this case? In accordance with the laws of Hong Kong, be it the DOH or any other organization, one cannot practice without holding a practicing certificate. So when the new provisions apply, the Dental Council of Hong Kong will have to inform all dentists of the latest requirements. As Dr. David Lam is right, some dentists may need to make their applications. Deputy Secretary, thank you. Under the Nurses Registration Ordinance is actually the same. After we have determined on the implementation period, the industry will have to be informed of this arrangement. Then the ordinance will be dated back and the relevant arrangements will be made known to the industry so that they will have to make their application as soon as possible. We'll make arrangements from the administrative perspective. Well, Dr. David Lam, what do you mean by already possessing the practicing certificate? It may have been already mailed to you, but then it may have gone lost in the course of the mail delivery. Can one only practice after one has received the practicing certificate? Will the DOH financially punish me? Will there be any fine incurred? Deputy Secretary, which official can take this question? We'll talk to the DOJ about this. We'll respond afterwards. Ms. Chen Ho-Yan, my question is similar. One has already taken the examination, has paid. Does one need to hold the practicing certificate? You have record on your own. That's an official certificate mailed to the applicant, but actually at that moment, the applicant has already passed the examination, but without holding the practicing certificate, one cannot practice. Is that correct? I'd like to clarify this point. One needs to hold the practicing certificate before one can practice. That is to say, one needs to hold the practicing certificate. Is that correct?
Deputy Secretary, We will confirm the understanding with the Department of Justice. We consider possessing or possession of certificate means the certificate having been granted by the dental council. I will have to confirm with the DOJ. Let me give you another scenario. What if the dentist relocate their clinics and they've lost the certificate? Can they only practice with a physical certificate of registration? Do we really have to rely on that piece of paper? Deputy Secretary, Ms. Lau. Thank you. We don't think that possession means physical possession. Perhaps we have to seek advice from our legal advisor. We have to look at the consequences of not possessing the practicing certificate. As the bill is rather long, I'm not able to identify where the provisions is. I have to go back and think about that. Professor Chen Wing-Kwong. Thank you, Chairman. I would like to follow up on Ms. Chan's question. I think that as long as we can identify the name of the dentist in the register, we should be able to allow the dentist to practice. Do we have to mandate the dentist to display the certificate on their clinics? Can we allow them to practice as long as their name is in the general register? Thank you. Mr. Chang, we don't require the dentist to display their certificate in the clinics. Dr. David Lam. Thank you, Chairman. Now, under the bill, if the dentist can only practice while they possess the physical certificate, this is not reasonable. I think as long as the name of the dentist is in the general register, they should be able to practice. Why don't you allow them to go back and think about it? I think that they've heard your views, and this question has been repeated time and again. Let me put another question. Just now, Ms. Lau said that they have to look at the consequences of dentists practicing without a certificate. Let me give you a suggestion. There are some 70 to 100 dentists who have their names removed from the register by not renewing their licenses. Some of them register for another license, and some other dentists were sued without a license, and sometimes they are fined $8,000. And after they've been fined, they could not renew their licenses, and they have to go for a restoration hearing, and that would take years. There were a medical doctor who is a friend of mine who worked in the construction site because they could not renew the license. No reply is needed for a question, is that right? Yes. Mr. Chang, please proceed. Now we will move on to 12A, qualification for inclusion in specialist register. For Chinese translation of the word council, we will change it from 委員會 to 牙管會, which means dental council. Now 12B, application for inclusion in specialist register. Bracket 1A, we will substitute in such form and manner as may be specified by dental council for the inclusion in the specified form. Bracket 2, we will be changing the Chinese translation of a council from 委員會 to 牙管會, which means dental council. And in bracket A, awarded a fellowship of the Academy of Medicine, we will include this phrase in the specialty of dental surgery. Under 2 bracket A, do we have to make the relevant amendments? I think that we should. That is why we will change it to a fellowship of the Academy of Medicine in the specialty of dental surgery to align the two provisions, to the effect that only people who have been awarded a fellowship of Academy of Medicine in the specialty of dental surgery can practice. And also, for the Chinese translation of the word council, we will change it from subcommittee 委員會 to 牙管會 dental council. The same amendments will be made to the following clauses. And for bracket 10, if the council approves the application of a registered dentist made under subsection bracket 1, the council shall, on receiving from the dentist the fee prescribed for the purpose, direct the register to so on and so forth. We will change it to must after the prescribed fee has been paid. Ms. Chen Hua Yan. I would like to ask about 12B. You said that you will amend bracket 1, a registered dentist who wishes to have his name included in the specialist register. If they don't wish to have their name included in the specialist register and claim themselves as a specialist dentist, what happens? Can they claim to be a specialist register without having a name included in the specialist register? So it seems that we rely on the wish of the registered dentist instead of whether they are qualified to become a specialist specialist dentist. Mr. Chang, let me add to the question. Can I say that I wish to have the name included in the specialist register if I'm not a specialist dentist? Can I claim to be a specialist dentist if I'm not? So if a specialist dentist wish to have their name included in the specialist register, they can have their name included. So we have to look at whether they're qualified, and also we have to look at whether this dentist wishes to have their name included in the specialist register. So if the dentist is not a specialist dentist, they cannot have their name included in the specialist register. So the premise is that the dentist should be a specialist dentist. Is that right? Yes. In bracket 1, it says that if the dental council has not approved the dentist to have the name included in the specialist register, they cannot be a specialist dentist. The premise is that the dentist should be a specialist dentist before they can have their name included in the specialist register. So the dentists have to fulfill certain requirements before they can have their name included in the specialist register. Is that right? Yes. That is why in the following sentence, it is said that they can apply to the council for the inclusion in the specified form. Chairman, so the dentist should have the specialist qualification before they can have their name included in the specialist register. Am I correct? The dentists have to apply to the dental council. If they're not qualified, they cannot make the application. So if I'm a specialist dentist and if I don't want to have the name included in the specialist register, is that possible? So if one is a specialist dentist and don't want to have the name included in the specialist register, they don't have to have the name included. Well, because some people like to take examinations. They may have all the vehicle driving license and they may not drive those vehicles. Now, it's said that, well, what if a specialist dentist passing the test don't want to have the name included in the specialist register? Can I claim myself as a specialist dentist if my name is not included in the specialist register? Is that possible? Yes. There were dentists who passed the specialty or specialist examination who don't have the name included in the specialist register. Can I claim myself a specialist dentist if my name is not included in the specialist register? No. There are dentists who have passed the specialist or the examination who don't want to have the name included in the register. Well, will you follow up on the reason why the dentists who have passed the specialist examination don't want to have their name included in the specialist register? Has this been the drafting of the provisions all along? The member is correct. It is said that in the law, a registered dentist who wishes to have his name included in the specialist register, so on and so forth. There were specialist dentists who passed the test who don't want to or didn't want to have their name included in the specialist register. The reason for why they don't want to have their name included is varies. Would you ask why the specialist dentists don't want to have their name included in the specialist register? No. Dr. David Lam, I have two questions. 12B, bracket 3, bracket A, bracket Roman number 4B. English version is certified by the Academy that he has completed the postgraduate dental training and the continuing education requirements. Should we not change it to continuous professional development requirements? Second, can a dentist register for more than one specialties? Mr. Cheng? Thank you for your question. Regarding specialist register, it does not involve continuing professional development. For medical council, they have a CME, continuing medical education. Can a dentist register for multiple specialties? There is not such a restrictions, but under most of the cases, a dentist can only specialize in one specialty, as restricted by the Hong Kong Academy of Medicine. So, are you saying that the dental council would not allow a dentist to register under two specialties? The Hong Kong AM can award more than one specialties for a single medical doctor. Our undersecretaries are under two specialties. They are registered under two specialties. Well, there is not such a restriction. I just want to say that under the CTSHK, not a single dentist is registered under two or more specialties. So you're saying that there is no dentist who have been registered under two specialties, and if the dentist is registered under two specialties, they will have their name included in two different categories under the specialist register. Yes, if a dentist is registered under two specialties, they can have their names included in two different categories under the register. Thank you. No follow-up question? Mr. Chan, please proceed. Thank you. We are at 12C. We'll be changing the Chinese translation of the word council from 委員會 subcommittee to dental council. 牙管會 12E, page 83 of the English marked up copy. For bracket 1, we will be changing the Chinese translation of preliminary investigation committee. For bracket 2, also the PIC Chinese translation will be changed from 小組 task force to committee 委員會. Please proceed. 12F. Again, we will be changing the Chinese translation of committee from 小組 task force to committee. This 委員會. It is for bracket 3. The wordings are the same as bracket 2, but we're just changing the Chinese translation of the committee. Starting from bracket 3 to bracket 7, we're changing the Chinese translation of council from 委員會 subcommittee to 牙管會 dental council. For Division 10, miscellaneous is about the requirements on provision of address of dentists with provisional registration. I will give you more details. First, because we will now put in place a provisional registration scheme that is dental graduates. They must provide register and address in Hong Kong at which they may be contacted. Bracket 2, subject to subsection 3, a registered dentist other than a registered dentist whose name is contained in the non-practicing list must provide the address of all premises in Hong Kong on which they carries on the practice of dentistry. This is the practice of the Dental Council currently. That is, if a dentist want to establish a clinics, they have to inform the address of the clinics to the Dental Council. What does non-practicing list means? It means that the dentists who are not in Hong Kong. For dentists with provisional registration, they are working in specified institution. They should not be asked to provide an address of practice. For bracket 3, some people don't have to provide address if they provide outreach medical service. We have to refer to Section 9 of the Private Healthcare Facilities Ordinance. If dentists provide services at school or the residence of a person, they don't have to give the address to the Dental Council. If they work on a mobile dental service vehicles, they don't have to give the relevant address to the Dental Council. And if the person carries on practice of dentistry not for gain, they don't have to provide the address either. If the dentist is working on a voluntary basis, they don't have to inform the council where they work. Bracket 4, a person who has provided an address under subsection 1 or 2 must report to the register any change of the address, including the address as changed and reported under the subsection within 2 months after the change. Bracket 5, we will be giving the dentist a reasonable defense. Now, a person who fails to comply with subsection 1, 2, or 4, they are liable to a fine at level 6. Now, under bracket 5, we say that if a person does not have an address, then they can have a defense. If a dentist has been hospitalized and they don't have time to inform the Dental Council of the change of address, they will not be liable criminally. Bracket 7 is a provision that is complementary to bracket 6. This is a defense and how it can be established. The person have to have sufficient evidence to raise an issue with respect to the matter, and the contrary is not proved by the prosecution beyond reasonable doubt. This is to explain what defense means. Ms. Chen Hua-Yan, I would like to ask about outreach medical service. Is that under 3A, any premises on which the person provides an outreach medical service? And if the dentists work at this premises, they don't have to provide the address to the Dental Council. We will be having a lot of mobile dental service vehicles. Should we not register the registration mark of the mobile dental service vehicles with the Dental Council? We use the word premises here, but actually we have a number of serial numbers attached to the vehicles, including the vehicle registration number and vehicle license number. We cannot allow just any vehicle without adequate medical equipment to provide such mobile dental care service. You only put the word outreach here, but then in your oral explanation, you mentioned mobile dental care services. We have been seeing more and more mobile dental care vehicles, as this is a new provision. Should we not ask the provider of mobile dental care service give the registration mark of the vehicles to the Dental Council?
因為根據翻私營醫療
Thank you for the question. Now, in the private healthcare facilities ordinance, what's meant by outreach medical services? That is, someone provides a service and different venues, then it's fine. So it's included. If it's a van that moves around, then strictly speaking, is outreach medical service. Yes. But the question is whether the registration number of the vehicle should be submitted. Now, for premises, there's no need to give address. But what about van? Well, there are NGOs already operating mobile dental care vans. But perhaps Dr. Ms. Chow could tell you what the regulatory arrangement is. Ms. Chow. Well, the Dental Council currently does not look at the cleanliness of these vans. That is, they can use any cars for mobile dental care services, and you won't ask for registration because you don't intend to check the cleanliness or the equipment of these on this premises or vans, right? For the time being, we don't have plans to do that. Ms. Rebecca Chen. Now, dentists need to provide an address of the practice premises because you will do inspection on the cleanliness and other aspects of the premises. But mobile dental care vans, I'm not talking about vans used for transporting patients to a clinic. I'm talking about a mobile van with some dental equipment, scaling, or even extractions carried out on the vans. Now, the Jockey Club has had huge vans for that purpose. And recently we're seeing more such vans because NGOs are also operating the vans. And then the van is parked on the street. It's just that the practice is not carried out on the premises, but rather is carried out in a van. And then there are consultation hours specified. So it's actually a clinic, but it's a mobile clinic. And then you mentioned provisional registration, and you mentioned internship. Maybe dental students will take up internship positions with NGOs, and because premises are expensive, so we're seeing more and more mobile dental clinics. So in the past or now, you don't have any regulation over such mobile clinics, but you should consider the new trend. Maybe you need to regulate such vans as well, because there's maybe problems with cleanliness and substandard equipment and so on. Yes, that's a very good suggestion. We will, yes, look at the current trend, and we'll see for mobile dental clinics, we'll see if they are not caught by our current regulatory regime. And so we'll take it up with the Dental Council. And after review, we'll give you a response. Can I just confirm one point? The Dental Council said currently there is no regulation over such mobile clinics. Is that correct? Well, perhaps the Department of Health could supplement. As far as I know, currently we do not inspect such outreach premises. Is there anyone from the Department of Health? How can we then ensure the standards? Dr. Hui? Now, with the information I have at hand, we have never inspected mobile dental vans. Well, do you know how many such vans there are in Hong Kong? Because maybe they're just converting lorries into such clinics. Well, they won't know because they don't ask for registration. They don't do inspections. So how can they tell how many such vans there are? But anyway, do you have an answer now? No, then perhaps they can go back and take a look. They will find out how many vans there are, and then they will see whether they've actually left out such vans for regulation or supervision. There's no point dwelling on this because we won't get any answers today. Dr. David Lam, thank you. For the private health care facilities ordinance, so mobile dental clinics should be included because this is where surgeries are performed. So under the Private Healthcare Facilities Ordinance, that should be looked into. But this Bills Committee is on this bill. Well, yes, I know, of course. Now, coming back to 12G of the bill. That is, all registered dentists have to provide the address of all the premises in which they practice dentistry. It seems rather complicated. If I have an additional clinic, it's fine. I register the address. But let's say I work on a part-time basis. I may work at different clinics, and I move around to different clinics frequently, and I don't know where I'm going to work next week. And then you want me to note the address where I worked, and then I have to report that out. Is it really necessary? Now, maybe if I'm I'm not just dentist. I'm a dental surgeon. I invite a dental surgeon to come to my clinic to see the patient and discuss treatment options. Then it's a paid service. So does it mean I have to report it also? Let's say I'm a professor in dentistry, but there's another institute, not the one that I work for, asked me to do a dental surgery demonstration, and it's paid. So again, do I have to report it? So really, is it necessary to have this requirement? I think is it enough if I just report the address of the premises where I usually work? But if I don't make the report, I may be held criminally liable. If you can prove that I purposefully not report, then it's fine. But if I forget to report, then I'm still criminally liable. Then I think it's too harsh. Deputy Secretary. The registration certificate that's mentioned about the address requirement. We're not any more harsher than any harsher. Now B, it says that each dentist, each registered, must then report every address where he's making a gain from his practice of dentistry. So this is, yes, you're right, it's criminal liability. And then 3E, that actually you can tell is harsher before because there's need to report at once. But now here, there won't be a fine even if there's a failure to report. Forgetting to report could be used as an offense, a defense. So in terms of the address requirement, actually in the bill, the requirement is less stringent. But I think there are now more dentists or doctors working on a part-time basis. If you ask them to report every address, it's really quite unnecessary. It's a nuisance. But they say in the past they've been doing that. It's nothing new. It's always been the practice. Okay, that's always been the requirement, but then with changing times, you need to change the practice. And otherwise, why are you amending the bill? Because now you're asked adding internships, so why can't you make changes here? Let's say I work at 5 or 6 different places each year because I can no longer afford to run my own clinic. I work on a part-time basis, and then my boss sends me to different clinics to work. And if I fail to report, then I'll be held criminally liable. So why is it necessary? Why is it necessary to provide each and every address of the premises where I practice? Is there a similar provision in other ordinances? Well, that's been the requirement in the dental profession. You're saying that we should relax the arrangement. Then even if they tell you there are examples in other professions, we still won't accept that. So, okay, you've asked a question. I think let's leave it to them, and the administration will come back on what they plan to do about that. Okay. Next, Mr. Professor Chen Wing Kwong. On outreach service, I understand in each dental clinic there has to be at least one registered dentist. So as Dr. Lam said, let's say I'm not a boss of that clinic, so I need to register, report the address. And for outreach medical service, there's also mentioned that any primers for the practice of dentistry, not for gain. So that's voluntary service. But then, say for Chinese medicine, if we do outreach service, we can just fill the piles and write a prescription. It's easy. But then for dentists, they need the equipment. They need the premises to be properly sterilized. And now we are seeing many mobile dental clinics. For Chinese medicine, we also have mobile clinics, but then we keep the vent very clean. But so here, it can't be just because it's not for gains and that there's no regulation or supervision. Now, not for gain, that's always been the practice of the Dental Council. That is 3 bracket B on page 86 of the marked up copy. So any premises on which the person carries on the practice of dentistry, not for gain, there's no need to provide an address. That's just the current practice of the profession. As for mobile dental clinics, yes, we can go back and take a look at that. And because it may have to do with the private healthcare facilities ordinance, we'll see if it's covered under that ordinance. Because our understanding is the matter is not intended to be dealt with in this in the dentist registration ordinance. So we will see. We will take a look at that further. Thank you. Please continue. 12H on page 87 in the English version. Transfer for practicing list to non-practicing list. Practicing list means the person practices in Hong Kong. Non-practicing list means that person does not practice in Hong Kong. So for 12H bracket 1, this section applies to a person A, whose name is contained in the practicing list, and B, who wishes to switch to the non-practicing list. That is, someone has been practicing in Hong Kong, but then now he wants to go overseas for further studies, then he could switch to the non-practicing list. And bracket 2 says the person may apply in the specified form for the transfer of the person's name from the practicing list to the non-practicing list. And 3, on receiving the application and on the payment of the prescribed fee, the person's name will be transferred from the practicing list to the non-practicing list in the general register. 12I, issue of retention certificate to person whose name is contained in non-practicing list. This is a new requirement, so I'll say a bit more. This section applies to a person whose name is contained in the non-practicing list. In the past, we call it the non-resident list. That means the person resides overseas. Maybe that we don't know about the status of the person. Maybe the person has passed away or has switched to a different profession. We wouldn't know. So here, this is a new requirement for retention of certificate. If someone is on the non-practicing list and the person wants to stay on this list, then the person will have to apply for a retention certificate. The application mechanism is spelled out in detail here. Bracket 2, the person may apply to the registrar in the specified form for a retention certificate. Bracket 3, on receiving an application and pay and prescribed fee, then the retention certificate would be issued, and there could be a condition specified. For example, if the person is emigrated, maybe the person has, and then the person wants to come back to Hong Kong and switch from the non-practicing list to the practicing list, then there may be a requirement that the person should have taken up certain continuous professional development training first overseas. 4, bracket 4, if a retention certificate is in force from the time issued is issued on an application during a year, in respect of that year, then the certificate is in force from the time of issue to the end of that year. Bracket 5, if a retention certificate is made during a year in respect of the following year, then the certificate will be in force during the following year. And bracket 6, a retention certificate ceases to be enforced if during the currency of the certificate A, its holder ceases to be a person with full registration, or B, the registrar cancels the certificate under Section 12J bracket 5. That means the person switches to the practicing list. Then the retention certificate will be cancelled. Ms. Rebecca Chan. Can the administration explain the legislative intent behind this provision? Because there's already 12H transfer from practicing list to non-practicing list, and then on top of the non-practicing list there will be another retention certificate. Because I didn't quite follow your explanation. Can you give us more information? Okay, let's say there's a registered dentist who's emigrated, so he's not practicing in Hong Kong and puts his name on the non-practicing list. Now, he's already on the non-practicing list, but then you're issuing him with another retention certificate. Then maybe that person won't want to put his name on the non-practicing list, because even if he's immigrated, he may choose not to switch to the non-practicing list at once. So what is the legislative intention of issuing the retention certificate? You mean is to allow the person to change his mind and come back to Hong Kong anytime to practice? Because you say it's a new provision. Now, there are over 2,000 dentists. About 10% or so are on the non-practicing list, the non-resident list. But then we don't know if these people want to come back to Hong Kong eventually to practice. So there is not a mechanism to ascertain if these people who are overseas have such intention. So for the registered dentists on the non-practicing certificate, we allow them to apply for a retention certificate. That this is to remind them that they could stay on the list. Now, without the retention certificate, maybe they have some who have emigrated for several decades. Their name is still on the non-resident list, but they don't plan to come back to Hong Kong to practice, but still we have to keep them on the list. And so that may give people the impression that there are more dentists than there really are, because these people have no intention to come back to practice, and there's no way for us to remove the name from the non-practicing list. But if there is the retention certificate, then we'll be able to ascertain if those dentists have any plan to come back and practice. So you mean this is a way for you to find out whether the person is going to come back or not at all. Maybe the person may not want to come back for the time being, but then they may still wish to keep their name on the list, right? Is that because already there is a practicing list and a non-practicing list. So this is between the two, sort of. That is, I'm telling you, I'm not here. I've not asked if they have to pay. So that means I'm not here in Hong Kong, but I'm still on the list. Do I have to pay for the retention certificate? So that's why they are now coming with this retention certificate. Yes, that person is no longer in Hong Kong, but it's for the person to indicate whether he wants to keep his name on the list. If he doesn't, that means we know there aren't actually that many dentists. So then they will affect the calculation for the dentist to patient ratio. Now, if someone decides not to come back to Hong Kong, he will put his name on the non-practicing list. And then you go and ask them, do you want to keep a name on the non-practicing list? And I say, well, I've already put my name on the non-practicing list, but you're giving the person another opportunity. I know you want to retain talent, but I think that's the duplication. That is either practicing or non-practicing, but now you're adding something in between, that's retention. So you say that there's no limit on the retention period. Is that correct? There is a limit. If it's a retention certificate, they have to keep applying for the retention certificate so they stay on the non-practicing list. Perhaps if we look at other provisions later on, that will explain it better. Now, if a person is on the non-practicing list, but he does not have in possession a retention certificate, then the registrar has the power to remove him from the non-practicing list, and that will address the issue of people keeping their name on the practicing list when they have no plan to come back to Hong Kong. Dr. David Lam. 12I bracket 3. Condition can be specified in the certificate. But I don't see any provision to there's no provision empower the dental council to add these conditions. Now, for full registration or limited registration, there is actually a provision that states specifically the dental council may impose conditions, but here there's no such provision. So it seems that there's no provision to empower the dental council to impose the conditions, but you're just saying that the person has to comply with the conditions. So I don't know how the condition could be specified. That's the first point. Secondly, the retention certificate has to be renewed every year. We're talking about someone who's left Hong Kong for some reasons. The person chooses not to work for the time being. So has it to be every year? Can you be more liberal, maybe say for nurses? The practicing certificate is renewed every 3 years. Maybe the nurse chooses just not to work for the time being. So can you allow a longer period?
支持
So you mean when that person comes back and says that I want to practice again? Well, that is to say, can the practicing certificate be good for 3 years instead of 1 year? We can discuss with the Dental Council of Hong Kong. We'll discuss with them the arrangements to see how we can make it convenient for dentists. Which provisions empower the Dental Council of Hong Kong to specify these conditions? There doesn't seem to be such provision for practicing certificates or registers. You set out that the Dental Council of Hong Kong does have the power to set out the conditions. In the absence of these provisions, I'm not sure whether the law will allow the Dental Council to specify these conditions. We'll study with the DOJ and we'll get back to members. Thank you. Ms. Chan Hao-Yan, just my recommendation. Just my suggestion. For nurses, for 3 years, then they can be renewed. Traditional Chinese medicine is the same, also 3 years. That's for your reference. Thank you. No further questions. Please carry on. On page 88 of the marked up copy in English, 12J, transfer from non-practicing list to a practicing list. If a person would like to come back to Hong Kong to practice, this section will apply. One needs to make an application to transfer the name from the non-practicing list to a practicing list. Bracket 3, an application must be made in a specified form and be made at the same time an application for practicing certificate mentioned in section 12A bracket 2. Bracket 4, on receiving an application made in accordance with subsection 3, the registrar must alter the general register by transferring the person's name from the non-practicing list to the practicing list on the premises A. The prescribed fee has been paid. B. The registrar is satisfied that the condition, if any specified under Section 12I bracket 3, has not been contravened. And C. A practicing certificate has been issued to the person under Section 12A, 11A bracket 2. On the transfer of the person's name, the registrar must cancel the retention certificate issued to the person that is still in force. Dr. David Lam, I don't quite understand subsection 3. One needs to have a practicing certificate before one can apply to transfer from non-practicing list to the practicing list. So if one is not on the practicing list, how can one apply for a certificate to apply for the transfer? The applications can be made in tandem. In other words, one has to obtain a practicing certificate before one can apply for a transfer from the non-practicing list to the practicing list. Is that correct? I'll ask my colleague to take this question. Ms. Chow, from the Dental Council of Hong Kong. Ms. Chow, thank you. Please switch on the mic. Ms. Chow has taken the seat of Ms. Leung. Ms. Chow, please. Thank you. The applicant needs to have a certificate of practice before one can obtain the certificate of registration. It's a little bit different from what Mr. Chang said. When one applies, I mean, one needs to apply and one needs to have the certificate. Then that person will be on the non-practicing list. Is that correct? Well, I don't quite understand. You mentioned the certificate of registration. All along, I have the certificate of registration. So I can choose to be on the non-practicing list or the practicing list. Now I have the certificate of registration. I need to transfer from the non-practicing list to the practicing list. In 4C, one of the conditions is that a practicing certificate has already been issued to the person. So do I have to apply for a practicing certificate first before my name will be put on the practicing list? But then my question is, if I'm not yet on the practicing list, how can I apply for a practicing certificate? Shouldn't you put my name on the practicing list, then I can apply for a practicing certificate, or a practicing certificate can be issued to me, is that correct? When one apply for a practicing certificate, we will amend the register and change that person's status. We can transfer that person from non-practicing list to practicing list. If one does not have, has not practiced in Hong Kong for 10 years, do I still have the practicing certificate? That is, I'm no longer residing in Hong Kong. I've left Hong Kong. I will no longer have a practicing certificate. Is that correct? That's correct. So when I want to come back, I need to apply with the Dental Council of Hong Kong for a practicing certificate. I need to apply for it and apply for transfer from the non-practicing list to the practicing list. So only when I have the practicing certificate can I be transferred from the non-practicing list to the practicing list. Is that correct? Yes, your status will be changed from the non-practicing list to the practicing one. Question answered, Dr. David Lam. Well, I think this practice is quite strange, but if it's effective, I have no comments to make. One more question regarding the retention certificate. Let me put it this way. I have a practicing certificate, and I also have the certificate of registration. There are specified conditions. If I want to take a break, can I be transferred from the practicing list to the non-practicing one? Yes. Then the practicing certificate will be cancelled immediately. Then I will have to apply for a retention certificate. On the retention certificate, are there any specified conditions? Will my specified conditions on the practicing certificate be moved from the practicing certificate to the non-practicing list? If not, will the conditions be changed? Deputy Secretary. Member mentioned arrangements. We can supplement in writing. Well, that's a hypothetical question. When you obtain the practicing certificate, will the conditions be moved altogether? Am I correct? Yes, thank you, Chairman. Well, you can reply in writing. Thank you. Mr. Tang Fei, thank you, Chairman. I appreciate the administration for the arrangements to transfer the dentist from the non-practicing list to the practicing list, reflecting the number of dentists that can indeed serve the public. Well, I think this is a good practice. For dentists on the practicing list to be changed or to be transferred to the non-practicing list. Maybe the dentist would like to travel around the world. At that moment, that dentist does not want to bother does not want to transfer from the practicing list to the non-practicing list, but the administration does not have any method to make sure that the person will change from the practicing list to the non-practicing list. It really depends on the awareness or the self-awareness of the dentist. Is that correct? Mr. Ronald Chang. When one dentist returns from overseas to Hong Kong, he does not have to register from scratch. The procedures are cumbersome. So when one applies for a retention certificate, it will be easier for that person when he comes back to Hong Kong. Ms. Chen Ho-Yen. Thank you, Chairman. This practice is favorable for those who have already left Hong Kong. When these dentists come back to Hong Kong to practice, we'll have more dentists to serve the public. Do you send the retention certificate to the dentist without the dentist having to apply for it? The retention certificate is something new. We didn't have it in the past. So when one transfer from the practicing list to the non-practicing list, right now you have the retention certificate. To transfer from the practicing list to the non-practicing list, one needs to apply at the same time. So when one applies to transfer from the practicing list to the non-practicing list, should you also issue the retention certificate to the applicant as well? Actually, can you do the same to the retention certificate? It's something new. This is a very good suggestion. Thank you, Ms. Chen. We'll consider it. Any more questions? No? Let's continue. On page 90 of the English markup copy, publication of information in General Register and evidence of registration. In section 13, we have amended some contents. Brackets 1, the registrar, after the 1st of January every year, the registrar must prepare and publish in the Gazette the list of the name, practice, address, qualification, date thereof, and other particulars. Right now, persons who are with full registration, limited registration, and with special registration should also be covered. That includes the name, practice, address, if any, qualifications, date of qualifications, and other particulars. All these should be covered. The law does not require the register address, considering the fact that some may put their residential address on the register address as well. That is to prevent the problem we mentioned. Brackets 2. Likewise, the registrar must, after the 1st of July every year, prepare and publish in the Gazette a list of these pieces of information. That applies to every person who is a person with a full registration, with limited registration, or with special registration on the 1st of July of the year. And secondly, whose name was entered in Part 1, 3, or 5 of the General Register between the 1st of January and that of July. Brackets 3. A person's name being contained in the list published under subsection 1 or 2 is a prima facie evidence that the person is a person with full registration, with limited registration, or special registration, as the case requires. Brackets 4. The absence of a person's name from the list last published under subsection 1 and from any list subsequently published under subsection 2 is a prima facie evidence that a person is not a person with full registration, limited registration, or special registration. Brackets 5. A certificate issued by the registrar stating that a person's name is or is not or was not contained in the General Register on a date is conclusive evidence of that fact. All these sections may be doubted by the court. We want to retain the current practice. Ms. Chen Ho-Yen. Thank you, Chairman. I'd like to ask about Section 13, Subsection 1. In the last paragraph, the name, practice, address, if any, qualifications, date of qualifications, and other particulars that the registrar considers appropriate. For a practicing doctor, you have already written all the information, such as qualifications, date of registration, education qualifications, and so on. But then you included the word or, and other particulars. But I don't see anything important that requires you to write down the word and others. Well, for example, the specified institution he worked at. We want to have that information reflected on the register as well. For example, the DOH, DHA, or some NGOs, people may want to know where that dentist works in. We think that is of use, so we will also include it. When one works in a clinic under the DOH or DHA, you should have record. Or do you mean any experience prior to that? Well, concretely, it means the employment address. It reflects which or who the employer is. Why didn't you set it out clearly, employment or employer? You just wrote and other particulars. Well, there shouldn't be any dispute. The administration simply wants to cast the net wider. Well, of course, the wider the better. That allows the registrar to have more flexibility. But there may be inconsistencies. Usually, you have name and other pieces of information as well. But this one may come with some new information. I understand your point of flexibility, but some citizens of the public may question, are there any special reasons behind it? Why do I need to provide more information? Mr. Ronald Chang, yes, indeed, we want to incorporate flexibility in the practice. Some citizens may want to have more information about the dentists. For limited registration or special registration, there may be conditions. So, should they be made open in the register? Next, let's move on to 13A. That's on page 92 of the English marked-up copy. It's about the publication of information in specialist register and evidence of inclusion. As soon as practicable after the 1st of January every year, the registrar must prepare and publish in the Gazette list of the name, practice address if any, qualifications, date of qualifications, and other particulars that the registrar considers appropriate of every person who is a registered specialist dentist on the 1st of January of this year. We want to know about the person who is a registered specialist dentist on the 1st of July of the year, or whose name was included in the specialist register before the 1st of January and the 1st of July, both dates inclusive of the year. Section 13A is in line with Section 13. Regarding Section 14 on page 93, exhibition of certificate of registration will repeal it. It's about fines in subsection 1. Regarding the situations in subsection 2, it will also be repealed. Section 15, correction of general register or specialist register. Subsection 1. The registrar shall from time to time insert in the general register any alternation or addition which may come to his knowledge in the name, registered addresses, or qualifications of any person registered. 1a. The registrar shall from time to time insert in the specialist register any alteration or addition which may come to his knowledge in the name, registered address, or qualifications of any registered dentist whose name is included in the register.
Bracket 1b. The registrar may, after prescribed fee has been paid by a person whose name is contained in the general register or specialist register, alter the entry in the register relating to the person, other than an alteration relating to the practice address or registered address of the person. So what does this mean? If the dentist have another degree and they want to have the qualification printed on the license, they will have to pay the dental council for the dental council to alter the certificate. Bracket 2, it said that the register must make an alteration to the general register or specialist register that is made necessary by any decision of the council. That is in line with bracket 1A and 1B. We may refer also to page 95 of the English marked up copy. The council may order the removal from the general register the name of a person, A, who is deceased. That's the same as the existing provision. B, who being a person with full registration, a person with limited registration or special registration has failed to obtain a practicing certificate within 6 months after the last of the following dates. It means that the dentist have to possess the license for the name of that dentist to remain on the register. The conditions are the date of the person's registration, the expiry date of the last relevant certificate issued to the person, and 3, the date on which the person's name is restored to the general register under Section 27A. If the dentist does not provide the register with the address, the name of the dentist will be removed from the general register. 4, an order made under subsection 3 must be signed by the registrar. 5, subject to subsection 6 and 7, the registrar may remove from the general register the name of a person, A, whose name is ordered to be removed under subsection 3 or whose registration under part is no longer in force. 6, the registrar must, if practicable, cause a copy of an order to made under subsection 3B or C in respect of a person to be served on the person as soon as practicable after it is made. 7, the registrar must not remove the name of a person from the general register in accordance with an order made under subsection 3 before. A, if the order is made under subsection 3B or C, and a copy of the order is served under subsection 6 subject to paragraph B, the expiry of 1 month after the date on which a copy of the order is served, or B, if an appeal is made against the order under section 23, the appeal is finally determined. Before that, the name of the person should not be removed from the general register. A, what constitutes failure to provide an address? It means that if the registered letter is sent to the person at the last registered address provided by the person to the register, a person is to be regarded as not having provided an address to the register. And if the person fails to acknowledge receipt, then it will also be considered that a person have not provided an address. Dr. David Lam. By as soon as practicable, it will not be possible for you to send the copy to the person if the person has been deceased. If you say that the dentist's name should be removed after the copy not having been registered, I don't think that's reasonable. So, is this as soon as practicable condition only apply to persons who have been deceased? Second, regarding registered mail and acknowledgement receipt, can the registered or correspondent address be a PO box? Mr. Chang. Ms. Chow, Secretary of the DCHK, will answer the question. Ms. Chow, please. Currently, Dental Council does not accept PO Box as a registered address. What about the first question? How do you deal with dentists who have passed away? Let me ask the question again. If you send me a letter, for example, and I do not reply you or sign or acknowledge the receipt, and then I have my name removed from the general register, should you not send me a letter informing me that I will have my name removed? Maybe I will sign the final letter that you sent me informing me that my name will be removed. For the dentists who have been deceased, perhaps you will not send them a letter, but for other dentists, you will not send them a letter informing them that their names will be removed. Ms. Chow, if the dentist does not reply to the dental council within 12 months of the delivery of the mail, we believe that the dentist is out of reach and we will not be sending them another letter. I think that he's asking that you should inform the dentist that they will have their name removed by sending them another letter. I don't think that there's any difficulty involved here. You can state in the letter that they will have their name removed if you don't sign or acknowledge receipt of any letter. And you can state such in the letter. Well, we will send the dentist who will have their name removed a letter. That's what we do. Thank you. Ms. Chan Hua Yan. Thank you. I would like to ask about 3B under clause 15. That is how the council may remove from the general register the name of a person. For a person with full registration, limited registration, special registration, if they have failed to obtain a practicing certificate within 6 months after the, well, as we mentioned, the retention certificate only lasts 6 months, or well, if they have to obtain the retention certificate within 6 months, but the retention certificate will only expire after a year, it seems that they are contradictory. If they don't obtain a retention certificate within 6 months, they will have their name removed. It seems that is not in line with what you said, Mr. Chang. I think that we can think about how we can amend the provisions. I'm not sure if my understanding is correct. If the retention certificate will expire within 6 months, the dentist will have their name removed. That's the other way around. Has your question been addressed? It says here, or within 6 months after the last of the following dates. We can think if we should amend the provisions. It is contradictory to the previous provisions. We should amend the arrangement with the retention certificate. We will consider it. Dr. David Lam, I would like to follow up on bracket 6. Dental Council's practice is that they will not send dentists who have been deceased a letter informing that the name will be removed. Should you not amend the provisions by dispensing with the words "if practicable," by stating that unless the dentist has been deceased, the Dental Council will issue them a letter? Wouldn't that be more clear, Mr. Chang? We will consider it together with the DOJ. I think we can improve the drafting of the bill. Thank you. Ms. Chan Hua Yan. We want to have many dentists in Hong Kong as possible. If we remove their names, then they will no longer be able to practice. If the dentists can be identified within 12 months, then they can continue to practice. I'm not sure if you've listened to the radio. There were parents who could not be reached out to because their address been changed. For Dr. Lam, maybe he is too busy to check their mails. As a result, they did not reply to the Dental Council. Do you have other ways to inform the dentist? Perhaps you can put up notice on the DCHK website or put a notice in the Gazette. Is there any other ways for us to inform the dentists about the decision? Do you have any newsletter or notice on the website? by which you can inform the dentist of the decision? Thank you. Ms. Chow? We don't have such an arrangement under the Dental Council, but we take removal from General Register very seriously. We ask dental practitioners who are friends with the dentist to see if they can reach out to the relevant dentist. But it is said that the dentists have to reply to you within 12 months. Some dentists travel around the world, and I think that this 12-month requirement is too strict. Just like social welfare department, they try to reach out to parents and students by different means. I know that you have certain assumptions and scenarios that you would like to propose. For dentists who want to practice, there will not be as negligent as to not reply to any letters sent by Dental Council. I'm just saying that you can try other ways to inform the dentist of your decision. Dr. David Lam, I have some technical questions. Bracket 3, bracket B, you said that a person with full, limited, and special registration, if they have failed to obtain a practicum certificate or retention certificate, as we all know, only dentists with full registration can obtain a retention certificate. Should we not refine the drafting of the provisions? I think that this is a good suggestion. Apart from address, we will see if there is any other means of contact. Under Clause 158, there will be reference to contact means, and we will elaborate on it when we come to it. If there's no other questions, please proceed. I think, well, we will be changing removal of names from specialist register. We will be including 18 or 18.8. Bracket 2, the Chinese translation of the council will be changed from 委員會 subcommittee to 牙管會 dental council, and the Chinese translation of the subcommittee will also be changed. We will be adding this new bracket 4. An order made under subsection 2 must be signed by the registrar. The reason why we have 4 to 7 is that we should set out the arrangements of removal. And we set out the follow-up actions to be taken here to align all the clauses. Bracket 4, it says that the order must be signed by the registrar. And 5, the registrar may remove from the specialist register the name of a registered dentist whose name is ordered to be removed. And 6, the registrar must cause a copy of an order made in respect of the registered dentist to be served on the registered dentist as soon as practicable after it's made. 7, the registrar must not remove the name of registered dentist from the specialist register in accordance with an order made under subsection 2 before the expiry of a month after the date on which a copy is served, and B, if an appeal is made against the order. No questions? Please proceed. Now we're at page 98, 15B, service of notice. We will be repealing it because there will be provisions on that later on. Now we're at part 12, dental care professionals. 15C, bracket 1. The registrar must cause a register of dental care professionals called the Register of Dental Care Professionals to be kept. 2. The Register of Dental Care Professionals must be divided into different parts of different classes of dental care professionals. 3. Each part of the Register of Dental Care Professionals must contain 1. The name, B. The register address and qualifications, and 3. Any other particulars of the person that the registrar thinks necessary. Bracket 4, the registrar is responsible for maintaining and the custody of the Register of Dental Care Professionals. That's like the arrangement with the specialist and general register. Dr. David Lam. I would like to put a question, not on this clause. On the composition of Dental Council Hong Kong, we know that dental care professionals are considered lay members, but they are registrants. Is this not just contradictory? Because they are registrants, despite being considered lay persons. They are lay persons in the dentistry field, but they are registrants. Mr. Chang. For lay persons, the definition is set out in the part on interpretation. Lay person means persons who are not dentists, who are not deemed to be dentists. So as long as you're not dentist, you will be considered lay person. Please continue. 15D, application for registration as dental care professional. Bracket 1, a person may apply to the registrar for registration as registered dental care professional of a class specified in column 1 of part 1 of schedule 3. Member may refer to column 1 of part 1 of schedule 3. The dental hygienist and dental therapist will be included, and we have a form stipulating what kind of dental care professionals can be registered. Bracket 2, application must be made in a specified form and be supported by a declaration. They have to declare whether they have been convicted in Hong Kong and whether they have been found guilty of unprofessional conduct, and if they are subject to any criminal or disciplinary hearings outside Hong Kong and in Hong Kong. 3, to avoid doubt, a person may apply for registration as a registered dental care professional for more than one class. It means that for dental hygienist and dental therapist, if I'm qualified for both professions, I can register under both classes. B, a person registered as a registered dental care professional of a class specified in that column may apply for registration as a registered dental care professional for another class or classes specified in that column. This may seem complicated. So what does it mean? It means that when we have more classes of dental care professionals, for creating plastic tooth, they may be considered class 2. For class 1, we have dental hygienists and dental therapists. So we allow a person to be both a dental therapist and a dental technician, for example. Bracket 4, if a person applies for registration as a registered dental care professionals for more than one class, the applications for each class is to process separately. A person can apply to become both dental hygienist and dental therapist, and their applications will be considered separately. Mr. Lam Chung Sing. Thank you, Chairman. Regarding this dental care professionals, they have to make applications in the specified form, and there are some requirements. We know that dental care professionals will have to have their license renewed every 3 or 5 years. You may also impose other conditions, for example, CPD of 20 to 30 hours. Is the arrangement reflected in the bill? It is mentioned that the Dental Council will announce appropriate conditions for the dental care professionals. If the requirements of CPD is not set out in the law, then there could be confusion. Can the government explain about that? The member is correct. The CPD requirements is stipulated under 15H. When the dental care professionals want to renew their license, they have to fulfill the CPD requirements. And the requirements will be set out in the practicing certificate. No more questions. Please proceed. 15E, determination of application for registration as dental care professionals. That's like the determination of application for dentist. 1. On receiving an application for registration as a registered dental care professional of a class specified In Schedule 3 made in accordance with 15D, the registrar must refer the application to the council. 2. Subject to subsection 3, the council must approve the application if the applicant is a person specified for that class. It could be dental care, a dental hygienist, or dental therapist. 3. The council may reject the application if it is satisfied after due inquiry that the applicant has been convicted of an offense punishable with imprisonment, have been found guilty of unprofessional conduct, or is not of good character. 4. The council may impose any conditions that the council considers appropriate. 5. The council must notify the registrar of their decision, and if the application is rejected, the reason for it. 6. On receiving the notification, the registrar must notify the applicant in writing of the council's decision, and if the application is rejected, the reason for it. 15E is aligned with the arrangement for dentist.
請繼續。
No questions, please continue. 15F, registration as dental care professional. That is, if an application is made for a class specified in Schedule 3, and if the council approves, then this section applies. Put simply, the registrar, after receiving the prescribed fee, must enter the applicant's name in the relevant part of the register of the dental care professionals for that class, that is either dental hygienist or dental therapist, and B, issue to the applicant a certificate of registration for that class. And then bracket 3 says that the certificate must be in the specified form. No questions, please carry on. 15G, scope of practice. Members may wish to refer to Schedule 3 later, because that will give you a clearer picture. Because here it just repeats many of the columns in Schedule 3. Members could refer to Schedule 3, and then it will be easier for you to follow this section. First, scope of practice. Column 1, specified class of dental care professional, they may practice dentistry, but it should be limited to just the scope of service in column 3. For an example, that if a dental hygienist, he can provide service in column 3, and so so that is the scope of service. It can't the scope cannot be exceeded. And then bracket 2, one condition is that all registered dental care professionals must be employed either by a registered dentist or a partnership of which at least one partner is a registered dentist, or an organization or establishment or body corporate that has engaged at least one registered dentist. So that's the condition under which a DNCP could practice. Now, if I may refer members again to Schedule 3, that is page 154. Then say dental hygienist. If the dental hygienist performs scaling, then we have to look at the conditions in columns 1 and 2 in part 1. And let's say page 157, there must be the patient must have been seen by a dentist with a dental record, and then the scaling is performed in the presence of the registered dentist. That means the requirements of Schedule 3 must be met in providing a service. Otherwise, if we go back to 15G, you see that then the CP may face disciplinary hearing from the dental council. 15H, practicing certificate required for practice. Now there is a mandatory continuous professional development requirement, similar to that for dentists. Now, a registered dental care professional of a class must not practice unless he holds a valid practicing certificate for that class. For example, if I'm or dental hygienist, I can only practice as a dental hygienist, but not as a dental therapist, for instance. And then 2, the council may issue a practicing certificate in the specified form for that particular class. If A, the applicant applies to the council for a practicing certificate for the class, B, the application is made in the specified form and contains information on the applicant's employment and practice of dentistry as required. C, the application is supported by a declaration by the applicant that the person has not been convicted in Hong Kong or elsewhere of an offence punishable with imprisonment, and if convicted, then the details of the conviction must be given. The D, the prescribed fee has been paid. And then the council must not issue the council must not issue a practicing certificate unless the council is satisfied that all the requirements have been met. And 4, the council must not practicing certificates for more than one class of DCPs in a category to a person at the same time. For example, dentists, hygienists, and dental therapists are allowed to provide direct service to patients. If the person holds 2 classes of registration, then in what capacity does that person practice? So the dental council would only issue one practicing certificate. This is to spell out specifically the capacity of the person in providing the service. And 5, if an applicant for a class holds a valid practicing certificate for another class, the council must cancel the existing certificate before issuing the new certificate. For example, a person is registered both as a dental hygienist and a dental therapist. The person holds a practicing certificate for a dental hygienist, but that person wants to become to practice as a dental therapist. Then the dental council will first cancel the practicing certificate of a dental hygienist before issuing the new certificate of dental therapist. And then bracket 6, the council must not issue a practicing certificate to a person who holds a valid practicing certificate issued under section 11.1a. 11.1a says that person is a registered dentist, and then that then the person will not be issued a practicing certificate as a DCP because the person is already a registered dentist. He can practice in both capacities. 7, the council may specify conditions considered appropriate in the practicing certificate. And 8, if a practicing certificate is issued during a year in respect of that year, then the certificate will be enforced from the time of issue to the end of the year. And for section 9, if the certificate is for a year in respect is issued in respect of the following year, then the certificate is enforced for the following year. And 10, practicing certificate issued for a class ceases to be enforced if the holder ceases to be a registered then DCP or the council cancels its certificate. For example, if the person becomes a registered dentist, then the council will cancel his certificate as an DCP. Mr. Lam Shan Sing. Well, we know we're going to leave the decision to the dental council on CPD, but do you have any initial ideas as to how what the CPD would be about? There are 2 classes, the dental hygienist and dental therapist. It's been explained just now, someone may have completed programs for both classes, but then the person can only possess one capacity at any one time. That's my understanding. And then the person may switches to a different employer, or even if the person remains in the same clinic, the person wants to take up a different role, and then the person will have to apply to you to switch to a different capacity. Is that the arrangement? Would it be too cumbersome, and would it take a long time for the application to be processed? I'll take the first question, and then Dr. Cho will answer the question on CPD. First, for the practicing certificate, if a person doesn't switch to a different class, that means the person, say, remains as a therapist, and there is no need to declare again if the person switches to a different employer. Now, say a person is a hygienist and then he wants to practice as a therapist, because he wants to perform extractions as well, for instance, then the person has to make sure that he switches to a different practicing certificate in a new capacity. And if the person faces a complaint or a discipline hearing, then we know in what capacity the person provides the service in the first place. Dr. Cho, on CPD, for registered dentists and then CPs, at the moment the Dental Council does not have any mandatory requirement on CPD, but after this bill is passed, the Continuing Education Committee will go by the guidelines of the Dental Council and then decide what CPD items need to be completed each year and the duration and so on. Okay. If there's no other follow-up, we will stop here for the clause-by-clause scrutiny. Any other business? Date of next meeting. The Secretariat will give notice to members. 20th of May 2024, 2:30 to 6:30, and then 4:45 to 6:45. And then 24th of May, Friday, 8:30 to 10:30. And then 10:45 to 12:45. If there are no other issues, I adjourn the meeting. Thank you.